Hello, I'm Kim Klahn. I'm a partner and employment specialist at Lodders Solicitors. I'm going to be talking about unfair dismissal and how you could dismiss an employee fairly. Employment can end for many different reasons, but it is vital that whatever the reason, the employer dismisses fairly to avoid a claim for unfair dismissal. To bring a claim for unfair dismissal, an employee must have at least 2 years continuous employment. To defend a claim for unfair dismissal, there is a twofold approach. Firstly, the employer must dismiss for a legitimate reason, and secondly, in reaching that decision, the employer must follow a fair procedure. There are 5 potentially fair reasons for dismissal. Capability. This can include things like lack of skill or even ill health. Misconduct, which can include disobedience of orders, dishonesty, or even fighting in the workplace. Redundancy. There is a statutory definition of redundancy, and provided that definition is met, redundancy can be a potentially fair reason for dismissal. Illegality. A good example of this is a lorry driver being banned from driving, therefore the employee would be unable to carry out their role. The 5th and final potentially fair reason for dismissal is some other substantial reason, and that is a bit of a catch-all category, but could include an employee refusing to accept a reorganisation or even a clash of personalities. The Employment Tribunal will consider whether an employer has followed a fair process in reaching the decision to dismiss. The first port of call for employers is the ACAS Code of Practice, which details what the fair process should be. It is possible for an employer to dismiss an employee fairly and avoiding the risks of an unfair dismissal claim in the tribunal. It is vital for an employer to have good record keeping and understanding the processes, and your employment lawyers will be on hand to advise if required. If you would like any help or assistance on any employment issues, then please do get in contact.